Welcome, everyone. This is Michael Morris, Executive Director of the National Disability Institute. We're glad so many people are joining us today from across the country. We had close to 1,000 people pre-register, and the numbers are getting right up there on the screen in terms of people joining us right now. This is a very important webinar called ABLE Accounts, Trusts, Financial and Benefits Planning. This is being brought to you by the ABLE National Resource Center, and we are pleased that sponsorship today of this webinar is being brought to you by Bank of America. Before I introduce you to the panel, and we want to take you into some of the logistical issues to provide you a effective listening environment. So let me turn it back to Nakia Matthews, who will tell you about some of those points. Nakia?
Thank you, Michael, and good afternoon, everyone. The audio for today's webinar is being broadcast through your computer. Please make sure your speakers are turned on or your headphones are plugged in. You can control the audio broadcast via the audio broadcast panel. If you accidentally close this panel, or if the sound stops, you can reopen this panel by going to the Communicate menu at the top of your screen and choosing Join Audio Broadcast. If you do not have sound capabilities on your on your computer, or if you prefer to listen by phone, you can dial the toll or toll-free number that you see here and enter the meeting code. Please note that you do not need to enter an attendee ID. And I will leave this up on the screen for just a few seconds longer in case anyone needs it. I will also paste it into the chat box. Captioning is provided during this webinar. The captions can be found in the Media Viewer panel, which appears in the lower right-hand corner of the webinar platform. If you would like to make the Media Viewer panel larger, If you would like to make the Media Viewer panel larger, you can do so by minimizing some of the other panels like chat or Q&A. And conversely, if you do not need or want to see the captions, you can minimize the Media Viewer panel. We will have time for some questions at the end of the webinar. Please use the Q&A box to submit any questions you have during the webinar, and we will direct those questions to our speakers during the Q&A portion. If you are listening by phone only and not logged into the web portion, you may also ask questions by emailing them to me directly at nmatthews@ndi-inc.org. This webinar is being recorded, and the materials will be placed on the ABLE National Resource Center website at the URL you see below. And finally, if you experience any technical difficulties during the webinar, please use the chat box to send a message to the host, or you may email me directly at nmatthews@ndi-inc.org. And with that, I will turn it back over to Michael.
Thank you, Nakia. Before I introduce the members of the panel, let me just put in context the discussion we're going to have today. The ABLE Act was signed into law in December 2014. In 2015, across this country, so many of you, people with disabilities, family members, advocates, and others worked with their states to pass state legislation which would authorize the establishment of ABLE programs. In the very end of 2015, with a change in the tax laws, there was a major change related to the ABLE Act. And that change is that no longer will a person who is eligible to open an ABLE account be limited to their state of residence. Once any state in the country opens an ABLE program, which we expect to happen very soon, in April, May or June, we expect some of the first states to open ABLE programs. Wherever you live, if you are eligible for an ABLE account, you will have choices to be made. We hope that the ABLE National Resource Center, www.ablenrc.org, will help you with information to make an informed decision. We do expect to offer comparison of key features of ABLE programs as states begin to open. And so please do visit that website. We thought before we could really get into what is going to happen in the next few months, this is the perfect time to have the kind of panel we've put together today. It is a panel of subject matter experts with different perspectives and different experience and expertise that we hope will help you shape your opinions on what to do, whether you are a person with a disability who may be eligible to open an ABLE account, you're a parent, grandparent, friend, relative, or others who are going to be making these choices in the months to come. This panel includes Kelly Thompson, a trust and estate attorney from the state of Virginia, Yolanda Mazik, Executive Director of Shared Horizons, a pooled special needs trust here in the greater DC area, James Sheldon, Supervising Attorney at Neighborhood Legal Services in New York, and considered one of the leading national experts on benefits under Social Security and also other programs that support people with disabilities, and also is a director of one of the WIPA work incentives advocacy projects funded by the Social Security Administration. We have as well Mark Fries, Vice President at Merrill Lynch, at Minnick and Fries Group, a financial planner and also a parent of a child with a disability. And we have William Thompson, Will Thompson, Deputy Executive Director of the Florida Prepaid College Board, which is going to be the originator of the Florida ABLE program, which is expected to open later this year. We've brought this panel together because we feel that each of these individuals has expertise we want you to hear about. The approach we're taking will be, first, I'm going to ask each of the panelists a set of questions to help you learn more about their expertise and help inform your future decision-making. And then we're going to go to some questions which will be open to the entire panel. Along the way, you will be able to put questions in the chat box, and we will try to get to some of those questions as well. We hope by the end of this hour and a half, you will be receiving new information, reinforcing information you already knew, but all of this is about helping everyone understand better the potential benefits and opportunities available from the Achieving a Better Life Experience Act as it moves to its next stage of implementation at states across the country, which will give people who are eligible new choices. So with that, let me turn to the focus of our discussion. What are critical factors needed to make informed decisions? What are the differences between various types of trusts? Would I want to open an ABLE account in addition to or instead of a trust? What is the range of costs involved in opening a trust or an ABLE account? And what is benefits planning, and how does it relate to financial planning? These are some of the questions we will cover. So first, I'm going to turn to Kelly Thompson, as I mentioned, an attorney in nearby Arlington, Virginia. She is a published author on trust administrations in Virginia. She has spent a great deal of her professional life focused on trusts and is considered by Washingtonian Magazine one of the top lawyers in the area, one of Virginia's super lawyers, and one of America's best lawyers. Kelly, I appreciate you being with us, and let me go to question number one. To sort of provide a context for some of the discussion today, could you briefly tell the audience what is a special needs trust?
Well, a special needs trust is a particular type of trust. First of all, we look at trusts in general are created for a wide variety of purposes. They may be for tax savings of one kind or another. They may be simply to make sure that there is management of assets for someone who is too young to do it properly or old enough to know better but still not getting it quite right, or to protect folks from exploitation. So a special needs trust could have all of those advantages, but the special part of it is it provides a way to shelter assets so that they are not considered as countable resources or countable income coming from the trust for benefits purposes. And we're thinking of benefits like SSI, Medicaid, and in some cases housing assistance.
Okay, let me go then to our next question. Well, having a little trouble with
Well, I think you wanted
pushing.
to talk about the various types of special needs.
There we go. There we go. Got it. Are there different kinds of special needs trusts? And also, is there something, quote, a typical customer that you find sitting across from your desk?
Okay. Well, some days I wish there was a typical customer. I don't find much typical in my office, but there are very definitely certain types of special needs trusts, and I often find that people are very confused by this, so it's good to spend just a couple minutes on what the types are. It goes into two broad categories, first-party trusts and third-party trusts. And the way to think of this is a first-party trust, the money is coming from the first and most important party, the person with the disability. Third-party trust, the money that's going into the trust comes from a third party, any third party, whether it be a parent, a grandparent, friends who want to help, whatever the source might be. So the first-party trust is a lot more complex than the third-party trust because the first-party trust is a very special exception in the federal law that says that a person under 65 with a disability can have this type of trust funded with their own assets. Now, when we talk about their own assets, that may be money that they're getting from a personal injury or medical malpractice settlement. It may be an inheritance that they're receiving that well-meaning grandma or great-aunt Sally directed directly to them rather than through a trust. It could be someone who becomes disabled later in life and has accumulated assets but is now disabled and needs to shelter them in one way or another. So those are all the various sources of funding, but a person under 65 with a disability can take those kinds of assets and put them in a trust and have them not count as assets or resources for benefits purposes. Now, SSI and Medicaid look at these trusts very, very carefully, and it's very difficult, trust me, to keep up with all the changes in regulations affecting these trusts. Because, let's be clear, the law is saying you can keep all this money and still get benefits. So there's got to be some regulation, is the perception, that must be there. The biggest regulation with these trusts is that at the death of the beneficiary, the person with the disability, that Medicaid must be paid back for whatever Medicaid paid out during the lifetime of the trust. So if I'm receiving Medicaid waiver services and then at my death Medicaid totes it up and says, okay, here's the amount we paid out for your benefit, Kelly, then my trust must pay back to Medicaid to the extent that the trust has enough assets to do that for those services that Medicaid provided. The Medicaid claim cannot exceed the amount in the trust. And if there is more in the trust than Medicaid is claiming, which is a case I have on my desk this week actually, the trust is worth $500,000 and the Medicaid claim is only $50,000, so the excess $450,000 can go to whoever the trust designated. It does not all have to go back to Medicaid. Now, a third-party trust is very different. So if I, as the parent of a special needs child, establish a special needs trust for my child's benefit, or it can be a grandparent establishing it, I do that a lot, then there is no payback to Medicaid because the money came from a third party. The assets never belonged to the beneficiary, the person with the disability. So that's the major differentiation between the two types of trusts. Now, underneath the category of first-party trust, there is also an option called a pooled trust, and that's provided by federal law. And one of the nice differentiations there is that the person with disability can set up their own account, trust account, because under a first-party trust, typically it cannot be established by the individual with the disability. It can only be established by a parent, a grandparent, or the court. So a pooled trust has a very distinct advantage of being able to be established by the person with the disability who has the legal capacity to do that. And then Yolanda will get into a little bit more depth about how a pooled trust works. There also are pooled trusts available for the third-party trust, and a lot of pooled trust programs that operate first-party trusts also operate third-party, although not all of them. So there is first-party trust and a third-party trust, and then underneath that there may be a pooled trust alternative under each category, which Yolanda will explain further. In terms of a typical customer, again, I wish there was typical, but it's what I love about my practice, is it's something different every hour. But a typical client is, first of all, a family, and often I get several generations of a family coming in together to plan for a family member who has a disability. So I work with the family on creating a special needs trust, often considering issues like guardianship, different benefits issues. That's a fairly typical customer. And it may be that I have the grandparents come in and say, okay, we're going to pay for this planning, but listen to the parents about how they want it to work. And then I may even have siblings of the person with the disability who are involved as well. And of course, as ABLE, we very often have the person with the special needs involved in the planning as well. The other instance is often where I do work directly with the person with a disability to structure a first-party trust. But then I've got everything in between. I work with other attorneys who are obtaining personal injury settlements and need help with structuring the settlement to make sure we maximize benefits. Really runs the gamut. Okay, let me see if I can get this to question 3, but I'll tell you the question and then we'll try to get it to change. There we go. Often the question we get all the time, and it's that, well, trusts are only for people with lots and lots of money, and it's an expensive thing to set up. Can you talk a little bit about what's the range of costs with associated with opening and managing a special needs trust, and albeit there are these several kinds you've mentioned, and is there a minimum dollar amount needed in assets? Okay. First of all, it's hard to talk about what's the range of cost in opening a trust because it varies greatly within a geographic area, and it also varies greatly from different part of the country to different part of the country. I belong to a group called the Special Needs Alliance. It's a national group of attorneys that do this kind of work, and I talk to my colleagues around the country, and I'm actually amazed at the wide range of fees that are charged. it's certainly, trusts are certainly not just for the wealthy. A special needs trust, it does not matter whether my child is going to inherit $5,000 or $5 million from me. The considerations are the same in terms of protecting their eligibility for benefits. So I see many, many families where all they are going to be able to leave their child is perhaps the equity in their home or a small life insurance policy, but that still needs to be protected, just like a wealthy family that may be leaving much, much more. So there certainly is no, trusts are only for the wealthy. That's not generally true anymore, even for non-special needs type trusts. So the range that you can expect to set up a third-party trust would be anywhere from several $100s to a couple $1,000 to set up a first-party special needs trust for assets that belong to the individual with the disability. Is a lot more complex, and probably the pricing would start at several $1,000s, and even more if you have to go to court for permission to establish the trust. In terms of what you have to go into a trust, a lot of people say, well, you can't have a trust unless you have at least $1 million because that's what banks require as a minimum balance. And that is not correct, because a trust doesn't mean it's at a bank. The vast majority of the trusts that I draft have a family member as the trustee. And so the only cost as you go forward in administering the trust is what that family member may choose to charge. I always provide that the family member can charge, but many of them, of course, do not, or they charge very reasonably. If a bank or a professional is administering a special needs trust, typically their fee is going to be something like 1 to 1.5% of the value of the trust annually. And in my experience, that's pretty uniform around the country.
Okay, thank you, Kelly. That certainly sets a certain context that we'll bring back into the fold when we begin to talk about ABLE accounts. I want to turn next to Yolanda. Let's see if we can get this to turn. There we go. And Yolanda Mazik is the Executive Director of a Shared Horizons Pooled Special Needs Trust that Kelly alluded to as one of the types of trusts that are available. Yolanda, can you expand a little bit more about your pooled income trust here in the greater Washington, D.C. area?
Sure. So Kelly did a fantastic job providing general information and specific information about S&Ts, or special needs trusts. But one of the things that Shared Horizons does is we serve as trustee for pooled special needs trusts. We are currently in D.C., Maryland, Virginia, and a couple of other states, only because we had people live in one of the 3 jurisdictions and they moved and they did not want to transfer their trust. So we went through the process of getting approved in that state. But we don't like to market in those areas. But for the pooled special needs trust, the difference between the pooled special needs trust and the S&T is that the pooled special needs trust, Congress allowed us to have one master trust document that is actually pre-approved by Social Security and the state Medicaid department in which we have been approved to operate in. So for most of the people that come to us, if they are working with an estate planning attorney, which we do encourage most people or all people that has a child with a disability to work with an attorney that can help them put all of their estate in order. Other than that attorney, there's no need to hire a specific attorney to draft the special needs trust document, because we've already done that and that's already been approved. So because of this, oftentimes there's a savings of costs and time that can be enjoyed because you don't have the additional expense of hiring the attorney to draft the document and then getting it approved. For the pool, in addition to having one master trust document, when Congress drafted the statute, they also allow us to pool resources for investment purposes. And what that allows us to do is when people join the trust, if they have 20,000 or 25,000 or even 100,000, instead of us having to establish an account specifically for that amount of money, we will add that amount of money for their sub-account to the large grand pool that we manage. And sometimes it just allows us to buy different kinds of products as opposed to having a smaller amount and being oftentimes limited with the specific types of products we can buy for investment purposes. As Kelly mentioned, for the Pooled Special Needs Trust, the person that has the disability can establish that trust for themselves. They don't necessarily need a parent, grandparent, or the courts. So they have that ability to come to us and say, I'm over-resourced, or I have an inheritance. I want to establish a sub-account within the pool. And also, as Kelly mentioned, there are two types of trusts that I would say most nonprofits that manage a trust. Oh, and by the way, you have to be a nonprofit to manage a Pooled Special Needs Trust. But most of the nonprofits that manage the Pooled Special Needs Trust, they manage both the self-funded as well as the third party. And Kelly pretty much gave you guys a summary of both of those accounts. Other than that, you know, we operate the same as every other individual trust. We have to follow the same rules and guidelines that Social Security and Medicaid outline and provide us when they approve the trust. The only other thing that may be different, and this will depend upon each individual pool or nonprofit that manages the trust, is that at the time of death, if money remains in the account, then for the S&T, Medicaid will provide that S&T or that special needs trustee with a lien amount or an amount that they've paid out for the person's care. The same thing will happen with the Pooled Special Needs Trust, but the difference is that Congress allows, because we are a nonprofit organization and because we tend to get smaller accounts, we don't get the $1 million or multi-million-dollar accounts consistently. What we can charge or the revenue that we receive from those accounts are limited. So for charitable purposes, Congress allows Pooled Special Needs Trusts to retain a portion of what remains in the account. Now, there are some trusts or Pooled Special Needs Trusts in the United States, and again, it depends upon the state and the agreement they have with their state Medicaid department. It will vary. For our particular trust, we retain or are able to retain 50% of what remains when a person passes away, and then Medicaid has a right to the remaining 50% if up to the amount that they paid out for the person's care. And if there's anything remaining after that, then it will either go to the deceased estate, or if they've identified a beneficiary to receive the remaining balance.
So Yolanda, you've grown in terms of beneficiaries of the Shared Horizons Pooled Special Needs Trust to, I think, over 600 beneficiaries. Is there a typical customer that you could describe?
A typical customer, I would have to agree with Kelly. It's difficult to pinpoint. We have anyone from someone that may be employed and they have a developmental disability and they are in they have a job coach, they are employed, and they find that oftentimes they are over-resourced. So they build up money in their personal savings account, and they need just a little protection or a little a means of sheltering their benefits as well as their funds. So oftentimes they may come to us. Initially, that's not the population we intended to work with, but we found probably about 3 or 4 years into managing this pooled trust that there was a growing population of people who are employed or who just typically find themselves over-resourced, and they didn't want to purchase another television. They had all of their vacations paid for, and they still had more than that $2,000 threshold that SSI dictates. So they will come to us, or they've come to us, and they ask us to create a special trust, which is we call a pilot program. So that's one type of typical customer, but then we have a lot of attorneys, whether they're trial attorneys, whether it's a settlement company, that are litigating and negotiating settlements for people. Some of them are small settlements, anywhere from $20,000, $25,000, up to over $500,000, which is our largest account. It's actually $600,000 within the pool. So our tips, there's no particular or typical customer. It is basically individuals that take a look at or weigh whether they want to go to an attorney to draft the document, or if they want the ease of the prepackaged idea of a pooled special needs trust. So, I wish I could be more answer, but I'm sorry, I can't, because it's a range. And it also depends upon the feeling that the family gets when they meet with our trust or the attorney or the other pooled special needs trust, because that, I say to people all the time, if when you speak to the special needs trust attorney or the pooled special needs trust, if you don't get a good connection, if you don't get a good feeling, then the relationship may be strained, and that's an important piece that I would encourage everyone that's looking for someone to manage their trust fund to ensure that they have that feeling and they have that trust before signing the documents and transferring the assets.
So one last question for you for right now is, everyone is concerned about fees. We talk with fee structure with Kelly. What's your fee structure at Shared Horizons?
So there's a one-time enrollment fee that every one will pay for the standard trust, and that's $1,000. So that's the enrollment that allows us to work with you to complete all of the documents, the joinder agreement. It allows us to establish your sub-account within the pool, within our accounting instruments and our accounting software, as well as just establishing your relationship within the nonprofit so that we have all of your information and your contact, your welcome packet. All of that is included in the enrollment. And then the annual fee is actually based upon the balance, much like Kelly mentioned, remaining in the trust. So we actually have a sliding fee scale up to $45,000. So anything under $45,000, the lower end for the standard trust, it's $450 annually. And then the next tier is $550, and then the next is $650, and then 1.5% for anything over $45,000. For the pilot program, it's because we recognize that it's smaller accounts coming in, we actually did a cost savings for folks that wanted to join the pool under the pilot program, and we reduced the enrollment fee down to $500. And again, that includes completing the joinder and all of what I just mentioned prior to. And then the annual fee for pilot, annually they pay $200 a year. for us to manage that account.
Thank you, Yolanda. And again, I'll leave it there for right now. I'm going to turn next to Mark Fries, who we are going to start with a few questions. Well, I can't move the cursor, so I will move instead to just introduce Mark as Senior Vice President, Wealth Management at Merrill Lynch. You have dedicated your financial planning career to working with families with a son or daughter with disabilities. First question is, where do you start? How do you help a family with financial planning who, of course, may have other children without disabilities, but have a son or daughter with disabilities? What's the beginning conversation like?
So, Michael, thank you much for allowing us to talk about this. The first thing I discuss with them is firsthand experience. So I have a son who's 19 years old, and so for most families, I've walked in their shoes. I know what they're trying to struggle with. I've struggled with IEP meetings. I've struggled with getting benefits and resources. And I know exactly what they're going through. So the first thing you have to do is understand their needs. The biggest question almost every family has is what's going to happen to my child when we're gone? And that's a tough question. And you have to try to figure out what planning are you going to put in place. So the first step is building a team. So the team would obviously be somebody who's going to take care of the money, who's going to be responsible for the money. Are you going to put money in a pool trust? Or are you going to put money in a special needs trust that the lawyer is going to draw up? And you have to look at all the legal. So as Michael talked about, it's not just that special needs member, but it's the whole family. Because in a lot of cases now, and using autism as an example, a lot of families, the parents are older. You know, they're in their 50s and 60s, and the child is still living at home in about 70% of the cases. So we need to make sure that's covered. We need to make sure they understand all the benefits that are available. Have they applied for Social Security benefits? Have they gotten guardianship done, which a lawyer would help with? What about health care? Who's going to handle the health care? Are there health care workers as backups? And lastly, I describe a letter of intent, which is a non-legal document that basically says, what's the roadmap that you have set aside for the next person taking over? So I ask the parents to kind of draw it up. They can put it in a Word document, on a pad of paper. What are all the things that you do on a day-to-day basis that somebody else taking over should know about your child? And a good example with my son would be, if you don't know about the strawberry jam that goes on his pills before he takes them, you're going to have a tough time ahead of yourself getting him to take those pills. Those are little tricks and things like that. Specialized planning, of course, is special needs planning because it's covering two distinct lifetimes. It's covering the child, which we obviously know has a disability, but it's also covering the parents. If the parents are not okay financially, then the child's not okay financially. So the parents have to be looked at as well. So this is not regular financial planning. It's not something that a normal planner can do because you're planning over a much longer lifetime. And as I mentioned, if the parents are not okay, then the child's not okay. So one great tool for this is the new ABLE Act. It's going to allow parents to put money aside. It's an important part of this strategy. It's one piece of it. You're trying to figure out how much money do I need for that child. And that's a tough calculation. So part of this, when you take a look at this letter of intent, you might also write down some numbers. How much I'm really spending on my child right now? How much I think they'll need in the future? What about inflation? So our firm, and if you email me, I can give you this information. We have a special needs calculator. It's free and complimentary. It allows you to do the beginning steps, which is to figure out how much is it going to cost for your child. So when you're figuring out, am I going to put money in ABLE or this pool trust or a special needs trust that Kelly might draw up for you, how much needs to go in there? And a really interesting rule is you can draw out about 5% out of a portfolio over 25 or 30 years and know that money will last. So thinking about if you're trying to replace $50,000 for your child, you need about $1 million. Most people don't have $1 million sitting around. So that's a very difficult task to come up with that money. So we review a lot of the potential problems. So when you're looking at investments, what are some things you should think about? You should definitely think about how expensive are the investments, how risky are the investments. The money needs to last your entire lifetime for you, and then also enough money set aside for that child. So those are some of the things we think about in financial planning for people that have a disability.
Let's go to the second question then, Mark. And as we all know, and we provided the context at the beginning of this webinar, no one anywhere in the country can yet open an ABLE account, but it's coming very soon. We know several states are going to open ABLE programs over the next few months. Are these questions you're getting from families coming in and talking to you about financial planning? What exactly is the level of interest you're seeing around ABLE accounts, and is this part of the discussion and providing information that is now part of your overall financial planning strategy?
So it's probably the hottest topic ever to come out in the special needs world in the last 30 years. So we're getting hundreds and hundreds of questions about it. When's it going to be available? How's it going to work? Should I use it? How's it, mixed with a pool trust? What about a regular trust that a lawyer will draw up? And so I try to use an analogy, like a bucket analogy. So I told you that originally, in order to generate $50,000 in income for your child, you need about $1 million. So unfortunately with ABLE, you can't put $1 million into that account. So ABLE is not going to be your only solution, but it's going to be a very powerful part of your solution. So I describe it as a bucket analogy. The first bucket you're going to get is you need to sign up if your child's eligible for Social Security benefits. You're going to start getting those benefits. That's one bucket of money that you'll be able to use for spending purposes for that child. The second bucket you're going to fill up is the ABLE account. It's $14,000 a year. I don't think any person that has means should not do something in the area of an ABLE account. I think it makes a lot of sense. And then the third bucket you would probably fill would be a special needs trust, something that a lawyer like Kelly Thompson would draw up for you. That is going to have a larger amount of money that can go into it. In fact, it's an unlimited amount of money. So all three of those pieces are going to be there and available for that child to be able to live off of. And most family members are going to need both. They're going to need all that money from all those three sources.
We go then to a third question, as I've asked of Kelly and Yolanda. Do you have a typical customer? Is there a way to describe that person or family?
So I'd say that in the special needs world, it's anything but typical. So typical or special needs family members spend $30,000 to $40,000 extra every year. Over a lifetime, it's about $1.4 million extra. So they're overwhelmed, they're overworked, and they're really desperately searching for answers. So what we try to do is calm them down, give them resources, educate outside family members so they know, give them a plan, because I mentioned somewhere around 70–80% of those children with special needs that are now maybe adults are still living at home. So how are they going to handle that? What's the program going to be for that? Most arrive at our door as referrals, or they've attended the many outreach programs we provide where we talk about ABLE and financing programs, how much money you're going to need. We usually do a panel type discussion, so we'll bring a lawyer in like Kelly to talk about how trusts work. We'll bring somebody like Yolanda in and talk about pool trusts. We may bring somebody in that's a benefit person. So that's how they've come to meet us. Parents come searching for answers. My logo is I'm the quarterback of your advocacy team. I'm really there to try to help you build a team, find out who you need in order to make sure your life with a child with special needs is easier.
And as I asked of each of our panelists, how do you define, or what's the methodology behind determining costs or fees for the family you're working with?
So when we work with a family, the first thing we do is try to help them figure out what resources they have available. So some of those resources, we don't charge anything for that. So how do you sign up for Social Security? When do you sign up for Social Security? How would you sign up for an ABLE Act account? What are all the differences between all the different accounts across the country, which we don't know yet, but they're all going to have different fund expenses. They're going to have different choices. The ABLE Act account was mirrored after the 529 account, which you look across the entire country. There's many, many different choices, and they're all different. There's different fee structures, there's different rules. Some have what are called lifestyle funds, which means that a particular fund would change automatically as far as the mix of assets over time, which might be good for somebody that's not savvy on financial planning. There are other ones that are going to have very low cost indexes, which are a lot less expensive than mutual funds. So we help the client figure out what are the best choices in that area. We also help them manage their own money because, as I mentioned, the parents have to be okay in order for that child to be okay. We do that on a discretionary fee basis, and that fee would range anywhere between 0.75%, so 0.75% to 1.5%, depending upon the value of the assets that we're managing.
And Mark, I'll just add one more question in here, and that is, any sense, and again, you have one of the larger practices in the DC area in terms of working with families with a son or daughter with a disability. Any sense of what percent you think in your overall planning an ABLE account will probably fit in and will be a part of your strategy?
Anybody I talk to better do it. I think it's a good program. There's really no downside to that program for someone. There's a lot of controversy about certain pieces. So the Medicaid payback is a controversy, but in planning as a financial planner, I think the ABLE Act account will be used more as an ongoing account, and so that means that we could tell the person to spend that down and not have any money left over when they pass away, because they're also going to have the other account available, which is a special needs trust account. So I think it's really good for a lot of people. I don't see anyone that shouldn't do it as long as they have the financial resources to do it. It's also going to be able to be funded by outside family members so other people can help. And I know personally, after talking to thousands of people over the years, if you have a special needs child, there are a lot of people around you that love you and want to help you. And so one of the best things you can do is tell them what some of these rules are, tell them that ABLE is now available, and this would be an opportunity for them to maybe help you and help fund that account if you can't do it on your own.
Thank you, Mark. Let me turn next panelist, James Sheldon. Jim is a supervising attorney at Neighborhood Legal Services, and you are not, for purposes of this panel, you're not a trust attorney. You're actually part of a nationwide system of what are called WIPA grants. Can you share with us what is a benefits advisor, and tell us also who's your typical customer?
Okay, thank you, Michael, and thanks for sponsoring this webinar. The most common use of that term, and you're using the term benefits advisor, which some of our funders use, it refers to an individual who counsels persons with disabilities who receive SSI or Social Security Disability Insurance, which I'll refer to as SSDI, and who are working or planning to work. Other terms that are often used to describe the same type of person are benefits planner, benefits counselor, or community work incentive coordinators. And typical customer, there's a few. We, under the Federal Social Security Grant, which funds the Work Incentive Planning and Assistance Project, or WIPA, our priority is people that are working or about to work, looking for work. And it may be somebody with a developmental disability who's going to be working part-time, maybe only making a few $100s a month, and there's some fear of losing cash benefits, but in particular a fear of losing Medicaid, right up to the college graduate, maybe advanced education person who is able to make 30, 40, 50. We have a person that we've counseled off and on for years who works in a government position making over $100,000 and still is able to take advantage of a special Medicaid work incentive known as 1619B. So the range of customers is quite broad. While I'm waiting for you to have your next question,
Jim, let me just take you back a step for a second, and I called it WIPA grant, but maybe for this large audience, who is a WIPA grantee? What is WIPA?
Okay. Work Incentive Planning and Assistance Project, and that's just one of the things that pays for this. For about, the past 16 years, earlier by a different name, the Social Security Administration has been distributing grant money that allocated by Congress to support benefits advisors or what Social Security calls community work incentive coordinators to do the work that I'm going to describe. As so many of the people on this call know, I'm sure, Social Security Disability, SSDI, and SSI are very complicated programs. And those rules get particularly complicated when it comes to work and earnings. And sometimes these rules can become a disincentive. Sometimes the complexity itself becomes a disincentive. But there's some very, very powerful work incentives, both to allow people to continue cash benefits for often a time-limited purpose, or in the case of Medicaid and Medicare, often the health insurance can continue indefinitely. The well-trained benefits advisor is going to be familiar with all these rules and in a position to guide the beneficiaries through all the, what I call the what-ifs. What's going to happen if I work at this level? What will happen with my cash benefits? What will happen with my Medicaid? And we'll even get into what's going to happen with some of the collateral benefits like housing subsidies.
And the next question is really, are there fees and costs involved in the services you provide and are being provided by the Social Security Administration funded WIPA grants across the country?
Certainly not for the WIPA grants. There's a growing number of states whose vocational rehabilitation agencies are funding this kind of service through fee-for-service arrangements, and in those cases there's no fees charged. The third kind of emerging funding source is some of the Medicaid waiver programs. Some of the newer ones are now able to build this into the services available through Medicaid waivers, and of course in those cases there would be no fees. I'm not aware of anybody charging fees for this service, but I suppose it could happen.
Okay. And our third question to you is, of course, this is about the coming beginning of ABLE accounts to be able to be opened by people across the country. How do you think the availability of ABLE programs will change benefits advising and planning?
You know, before I answer that question directly, I want to urge anybody on the call that if you really want to dig into the issue of SSI and Medicaid, which is what I'm going to address in a second here, the Social Security Administration just last week, the 22nd, put out I think it's a second iteration of their POMS, or Program Operation Manual System provision, and it's in SI 01130. And it's a very exciting read if you've been doing this very long. What's going to happen, I think, is the availability of ABLE will allow the benefits advisor to offer just one more tool that's going to support the move to work, and in many cases, financial independence, while they retain cash benefits and Medicaid. And just a couple of brief examples that may kind of drive this home, and it kind of shows the extremes of who we work with. The SSI rules contain any number of provisions that make it tough if a family member wants to assist their loved one, particularly with something like housing costs, say to rent a little bit nicer apartment. You do that and you're going to see the amount of the SSI payment diminish. If you help somebody establish a bit of a better bank account, as somebody previously mentioned, you're going to bump into that $2,000 asset limit for SSI. So in these cases, the ability for a family member to contribute to an ABLE account, if you look at the SSI regulations, if distributions are made to pay for rent, those are not income, those that money is not going to be considered income to the SSI beneficiary. That is absolutely huge, because right now, if somebody got free rent, their SSI payment could be reduced by up to 1/3. Now, the second example is we are seeing a growing number of individuals who are able to work their way off SSI but retain Medicaid through something known as the 1619B work incentive. Great work incentive. The problem is you still have to meet the SSI asset limitations, even though you may be making $50,000, $60,000, $70,000 a year or more. And what this does is allows that individual to put some of their excess earnings up to that yearly limit of $14,000 into the ABLE account as they save toward any number of designated expenses. And if you start looking at the list now, it's a very, very broad list. Right now, somebody on 1619B is not able to really set aside money to say for housing, to maybe a home purchase, vehicle purchase, or even a rainy day fund. ABLE account up to that $100,000 a year cap is going to allow them to do that. And I encourage people to look at the SSI POMs I mentioned, because if the account exceeds $100,000, and we're talking several years off because there's not even an ABLE program operating yet, even though the SSI benefit would be suspended, the Medicaid would continue indefinitely, even though the assets in the ABLE account exceed $100,000, as long as they would meet all the other SSI resource requirements. So this is going to open up a whole new tool chest, so to speak, for the benefits advisors who are advising people who are working at those higher levels of income but need to retain Medicaid.
Thank you, Jim. Those are some excellent examples. I will mention that the Social Security POMs, or program guidance, you can find on the ABLE National Resource Center website. So go to ablenrc.org. You'll find that. Let me go to our last speaker and member of the panel, Will Thompson, who is key to the design and development of the Florida ABLE program. Will, thank you for hanging in there. Had a lot of information to cover, a lot of questions and answers, but you are the member of the panel in a state is expected to be one of the first states to open an ABLE account. So again, for this very large audience across the country, can you briefly share what's an ABLE account going to look like in Florida?
Hi, Michael, and good afternoon to everyone. Thank you so much for the opportunity to join you. As everyone's been discussing, ABLE accounts have been very frequently discussed. And just high level, how do I know if I'm eligible for an ABLE account? And an ABLE account are for individuals with disabilities. The disability must be marked and severe as determined by the standards set by the Social Security Administration. So if you currently receive SSI or SSDI for the disability, that disability would qualify. If you would otherwise meet the standard, but maybe can't meet it right now for income or asset reasons, that disability still qualifies. The federal legislation has put an age limitation for the onset of the disability. So if the disability occurred before age 26, if the onset of the disability was before age 26, regardless of your current age, you are eligible for an ABLE account. The other limitations are that you can only have one ABLE account nationwide, and the individual with a disability is the owner of that account. So that just lets us know who is eligible currently under the federal law to establish an ABLE account. Real quick, why would you want to open an ABLE account? The two primary reasons are tax advantage savings. you can put up to $14,000 per year in this account, and it works like a 5 to 9 college plan or a Roth savings account. This is after-tax money that you're putting into an account, and those funds can grow tax-free. The other advantage is to maintain your Social Security income, SSI, or your Medicaid benefits, because the assets inside of an ABLE account are disregarded for those programs. There is an exception with regard to SSI, where if the account balance exceeds $100,000, that excess counts as a resource for SSI purposes. Social Security Administration would also look at housing expenses paid for by an ABLE account. So those two items, if you receive SSI, we would want to look through that information to see, to make sure that the ABLE account is set up right for you. With respect to Medicaid, regardless of the balance, it is disregarded for purposes of Medicaid calculations.
And in terms of what's coming soon, can you give us a peek a little bit under the tent where you're working on the design of the Florida ABLE program, of how it might be different than other states?
Sure. First, the federal law provides the structure of ABLE accounts that we just discussed. Other states may have requirements. The requirement with Florida is that you must be a Florida resident. So we are launching a qualified ABLE program in Florida called ABLE United. In order to enroll, the individual with a disability must be a resident at the time of enrollment. If they subsequently move, they can retain the plan. We anticipate seeing a variety of other states open up to their residents and nationwide, but to offer their in-state residents more than likely an additional benefit. That benefit may come in the form of lower fees, community involvement, knowledge of the state benefit programs that are specific to that state to ensure that you have the information to know how you're utilizing the account, and potentially tax incentives, tax deductions for those contributing to the account. So those are some factors that you're going to want to look at. As far as some other differentiators between, say, ABLE United and other qualified ABLE programs, while the $14,000 a year contribution is the same across the board because that's federal, the maximum amount that you can have as a balance and continue to contribute, we anticipate to vary by states between $200,000 to the high $400,000. So for example, in Florida, you'll be able to have an account balance up to $418,000 currently, and that you can contribute up to that amount. After that point, the balance can continue to grow, but you will not be able to contribute further until the balance drops below $418,000. With respect to fees, we do anticipate there to be some a wide variety of fees charged by states. However, it's still within a small range. So we expect most states to be $60 or less per year, and on the asset management side, 60 basis points or less for any direct sold model. In other words, a financial advisor is not involved. From there, fees could go lower. You could be all the way to potentially free, but $0 to $60 and some amount up to around 60 basis points for investment manager fees. You can also see a method of withdrawal. You can have checks made out to third parties that the individual with the disability wants paid. You could withdraw down to a checking account to satisfy a bill. Perhaps the Qualified ABLE program will offer a debit card or a prepaid card for immediate access. As mentioned earlier, there will be some different investment options, so you'll want to look at the risk tolerance to determine, are you looking for a savings option like a money market, where you're more concerned about the principal, Or are you looking for the opportunity to grow the asset and therefore are willing to take on a little bit more risk and therefore would look at investing in stocks, bonds, or one of those lifestyle funds that was mentioned earlier? The last two quick points. You may see some ABLE programs that will have a certain minimum amount required or a duration for those funds needing to be held to invest in certain investment options. For example, you would have to put in $3,000 to invest in this international equity option. That may be the case. You also might want to look at who can administer the account. Is it just the individual with a disability? Is it a parent? Is it a caregiver? Are there multiple people? So just highlighting for the ABLE United program, the maximum is $418,000. The fees will be less than $50 and less than 50 basis points. We're finalizing. We obviously would like those to be as low as possible. The method of withdrawal that we will be offering is to be able to send checks or have an electronic deposit of funds. The investment options, we have a savings option, like a money market. We have investment options for a fixed income, a domestic equity, international equity, and then 3 diversified portfolios characterized as conservative, moderate, and growth for you to select from. We do not have a minimum contribution amount, nor any requirements to invest in any of those funds or a duration. If you put the money in, you can take the money out, whatever, next month. And with respect to who can administer the account, the individual with the disability may be able to utilize and administer the account. A parent or legal guardian may assist and take on the role of an administrator and work with the individual with the disability. And we are working to have a number of other parties be able to assist the parent, legal guardian, and individual with the disability in the proper administration of the account.
Will, thank you for that information and that glimpse of the coming program from Florida. As you mentioned, the Florida program will be for Florida residents only. That immediately drew multiple questions in the chat box. People concerned that what if other states make that choice and limit their ABLE program just to residents of their state? I suspect, Will, you could comment on that. We already know that states like Ohio, Nebraska, Michigan, Virginia, and others are definitely planning programs that will be national in scope, and they will be marketing to people across the country. But, Will, I wonder if you have an additional comment about that.
Thank you, Michael. No, we anticipate to have a range of states and many states offering a national program. Ohio will be one of the earliest, if not the earliest, national program. We are launching in June for Florida residents, once again with that focus of keeping the fees low for Floridians and offering specific Florida resources and community involvement. We look forward to the opportunity to consider opening up nationwide, but for right now, we are Florida resident only. We do anticipate many members on this call who are not Florida residents, that there will be a number of options that will be opened in 2016.
Thank you, Will. A question early on, and I think I'll direct this one to Mark. Several commenters in the chat box. How can a person or a family find a financial planner with the appropriate knowledge and experience that will consider ABLE alongside other strategies that you mentioned?
So I think when you're looking at financial planner for any purpose, you have to look at their background, their credentials, how long they've been in the business, do they have experience in whatever subject you're interested in. Obviously in ABLE, they have to understand the special needs world. So example, on our team, we have 2 people that are certified financial planners. I have a certified retirement planning counselor designation, which allows me to do complicated and complex cash flow analysis, so how much money you would need, how long the money is going to last. The American College has a chartered special needs advisor designation, which one of our team members has. That's another way you could check into that. And then most major brokerage firms also have some sort of toll-free number you can call up and say, I need an advisor that has special needs expertise. I know my firm, which is Merrill Lynch, definitely has that, so you could look that up and do a Google search and find that number, and that would be a good way to do it. But I think that the most important part is that they really understand the rules, and in the special needs field, there are a lot of rules. Kelly talked about a lot of them, Yolanda talked about a lot of them, and those rules are important to understand, because if you don't understand what those rules are, you're going to have trouble making the right decisions. And the last thing is you're going to need resources. I call myself a Rolodex because I'm old school and over 50, so it's a Rolodex back then. But I know pretty much everybody in the special needs world in Virginia, Maryland, D.C. If you need something in the healthcare area, or you need your housing fixed, or something improved on your house because you have a special needs member that has special needs as far as moving around and things like that, you need to have a resource. Somebody who really knows that area well, and that's what you're really looking for. So that's what I would try to find. Somebody who has a lot of expertise in it, has been doing it for a long period of time, and has credentials backing those skill sets.
And Kelly, it seems a similar question for you. How do I find in my state or local community an attorney who has the appropriate background and experience and expertise to consider my options for my son or daughter with a disability? Kelly, do you have some suggestions?
Yes, I think, first of all, as I mentioned, I'm a member of a national group of attorneys called the Special Needs Alliance. They have a website, specialneedsalliance.org. The members there are all by invitation only and are regarded by their peers as, superior knowledge of and practice in special needs planning. If you go to the website, there's a map there, and you can just click on your state, and it'll give you a list of folks in your state who do this kind of work. Another resource, because there are a few states where I don't know anybody, another resource would be to go to your local ARC or Autism Society or similar chapter and ask them for a referral. I think is often a very good resource. Those would be my 2 primary suggestions.
Thank you, Kelly. Another question, or there are several questions like this, is I'm a person on SSI. Can I open an ABLE account? Can I contribute to an ABLE account? There are questions about if a person has a pooled or special needs trust, could they move money from a special needs trust into an ABLE account that they are opening or have open? Maybe Yolanda, you want to comment on that?
Can you hear me? I'm sorry.
Yes.
Yes, I'm sorry. I'm actually going to need to defer to the other experts on the line. I really don't know how to answer that as far as whether they can move money from a special needs trust. I think that that would be perfect for us managing accounts, especially since the ABLE account will allow rental payments. We live in D.C., so housing is such an issue for our beneficiaries that live in this area trying to find affordable housing. So I actually would like to have that question answered as well.
Okay, maybe who wants to try that one?
I can give it a try, Michael. Jim?
Okay. Yep.
As I read, and the main thing I've been reading are these POMS provisions for SSI. As I read them, and I think they use the term person, a trust is considered a person for the purposes of who can deposit money into an ABLE account, and then they, along with anybody else making deposits during a calendar year, would be limited to that $14,000 amount as it's indexed for future years.
Okay. I'm going to turn this to another question for Kelly, and that is for families who have assets that are tied up in a special needs trust, could they contain a clause that would either mandate or permit the trustee to make transfers on a regular basis to an ABLE account?
Well, I'm not certain that you really need a particular clause or authorization in the trust typically, because usually a special needs trust says that distributions may be made from income or principal to or for the benefit of the beneficiary. So establishing an ABLE account falls under for the benefit of the beneficiary. So I don't think any specific authorizing language should even be necessary.
Okay. I'm going to go back to Jim Sheldon. Several questions about, you gave one of your examples of the way qualified distribution of funds from an ABLE account can support housing, and it's very different than the current rules for people under SSI. And several people would like you, can you go over that again and do it a little bit more slowly and accent the differences between what you might do under ABLE versus what the current rules are before ABLE program came along?
And probably best to kind of state the general rule for people on SSI without ABLE accounts, which is everybody right now. If you get free housing, somebody's paying for your housing, somebody's allowing you to live with very minimal rent so that it's far below market, there's a concept known as in-kind support and maintenance. And the value of that free housing is going to be given a value up to a maximum of 1/3 the federal benefit rate. That's 3 into 756, no, 756 or 733. I have to remember state supplements. And so that's the general rule. When you read those POMS provisions, and somebody wanted me to restate the number, it's SIO1130, and then it's section 470 of that. When there's a qualified, a designated expense for housing, qualified disability expenses for housing, they could be paying the full rent, and I can't see that there's any limitations on amounts. The SSI program is not going to count that as income. So that things could be set up. A loved one could be putting $14,000 a year into that account for the sole purpose of subsidizing their housing expenses without any impact on SSI. I like to call something like this a non-event for SSI.
Right. Very good. Thank you. We also had some additional questions about the Medicaid payback. And one commenter suggested or is asking, does any state offer an annual statement to you so that you would have a better understanding of how much dollars from Medicaid have been expended, so you might make adjustments accordingly in terms of your disbursement of funds from an ABLE account? I personally am not aware of that any state has provided that type of annual accounting, but I'm going to ask whether particularly maybe Kelly, Jim, or Yolanda, you're aware of that. That would be very helpful to individuals and families. But does it exist?
It does exist. It's actually very helpful. Maryland provides it routinely. Virginia provides it upon request. North Carolina provides it upon request. Those are the states that I have experience with.
And D.C. will provide it upon request as well.
So it is an option, and perhaps that's something people can push for in more states. If in your state that is not available because of just maybe the pressure, the advocacy hasn't been there yet, but it certainly would help with planning purposes. Excellent.
I encourage my clients to request it because it's a whole lot easier for them to monitor on an annual basis whether the charges are correct, rather than at payback on termination of a trust trying to look at 20 years worth of charges.
And I'm going to come back to you, Yolanda. One of the early questions was, the commenter said, I don't understand this pool concept. Can you explain that a little bit more in your pooled trust?
Sure. The pooled trust was actually created, probably my understanding, from Marty Ford, who was instrumental in working with Congress to establish the exceptions for transferring assets into special needs trusts in the 9th hour. So they created the S&T, they created another trust opportunity, but then they realized that having assets between, $500,000 and $2,000, that threshold, that SSI threshold, is huge. And in their minds, I guess they were thinking that a person could go to a bank or a person could go to an attorney to draft a document, but then it might be difficult they may have a difficult time finding an attorney or certainly a bank to manage a trust account if it were under a certain amount. And let's say I'm going to throw out an amount less than $250,000. So they created the pool concept, thinking that it could create a more of a cost-effective way for families of modest means to establish a shelter for their loved ones that have disabilities without incurring or having to have over $250,000 or $500,000. And the way they created that or allowed that is we're going to allow the nonprofit to create one master trust document. That is the document that is pre-approved by Social Security and Medicaid. If you have an individual trust, you go to an attorney, they draft that document for a self-funded trust. They draft that document, then that document is approved by Social Security and the Medicaid jurisdiction in which the person lives. But for the pooled special needs trust, that part is already done. The only thing you need to do to establish an account within a pooled special needs trust is to complete a joinder agreement. That's the legally binding document that establishes your relationship or your loved one's relationship with the pool. We, as the nonprofit, our responsibility becomes to manage each sub-account within that pool. So you join the trust. What you have transferred in is what we have to work with during the process of managing your trust account. Of course, you're going to have some interest earnings and you're going to have some dividend earnings, but for the most part, we're going to sit down with you, create that quality of life plan, create a budget, and then we're going to take a look at what your needs are so that we can best manage that account. So it's a pool. It simply is that, a pool for the master trust document as well as investment purposes. That's why they call it a pool.
Thank you, Yolanda. There is a question about is there any effort being made to raise the eligibility age of onset, age 26 or younger, and there is legislation has been introduced in Congress called the Able Age Adjustment Act, which would raise the age of onset up to age 46. Time will tell how Congress deals with that and whether their momentum is built behind it. There was also a question asked about, can an individual move funds from a trust to an ABLE account, and can funds be moved from an ABLE account to a trust? Maybe, Kelly, you could answer that one.
Well, I think we answered a moment ago the question about from a trust to an ABLE account, and yes, I think that can be done and would not require any particular special authorization in the trustee. It would just come under the trustee's normal discretion. From an ABLE account to a trust, the distributions from an ABLE account have to be for a qualified disability expense. So moving the assets to a trust would not meet that criteria. So, I think it could be done depending on who has legal authority over the account. It's over the ABLE account. It's then just going to potentially be counted as an asset even for just 1 month of the person with the disability, and it could impact benefits. But some of these things, kind of remain to be seen depending on what we see as how these ABLE plans are written when we start seeing them roll out.
Yeah. Thank you. Thank you, Kelly. Mark has a further comment.
I'll just add on that. I mean, that's where a financial planner comes in. So why'd you put the money in the ABLE account in the first place? Were we planning to spend the money down? Because if you have a special needs trust on the side of that, you don't need to do that. You don't need to make those changes. So that's very, very, very important. The other question I saw out there was, when you set up a special needs trust, do you have to keep it? If all of a sudden, and I do a lot of work with younger families that have a newly diagnosed child, no, the special needs trust is basically, it's an empty pool that's there available, and it's available when you might need it. If you don't need it, then you don't have to have it. So don't, delay in doing that just because you think your child might get better or might get over whatever the disability is. It's a good bucket to have available, because if there is a problem, it's open and it can take assets in of all different sorts. So that's what we recommend in that regard.
Thank you. A related question was, if a child has a 529 account already, can you change that to a 529 ABLE account? Well, you can't change it, but you could take funds from a 529 account and could you move them to an ABLE account? No. According to the current rules, that would not be allowed because 529s have limited purposes for distributions: college tuition, housing, books. So it can't go that way. And so that's one of the limitations. There was another question asked about, what if I move to another state? ABLE accounts are portable, and you have a choice of holding on to your account from your original state. That was taken up in the guidance from IRS and Treasury. Or you could select to put the money and open the account in the new state. We've covered a lot of ground. I'm watching the clock. I think we're just about done. We will continue to look at other questions that came in, try to build responses from our panelists. I do want to thank each of our panel members today. A lot of information. We've covered a lot of ground. Hopefully we have accomplished our objective, giving you more to think about in making decisions about ABLE programs and ABLE accounts. As we mentioned, states will be opening ABLE accounts very soon. We do expect this to happen by this summer, and you will be able to find information about the ABLE programs that are opening on the ABLE-NRC.org website. We appreciate the funders of the website right now, Bank of America, Wells Fargo, JP Morgan Chase, and Intuition, and First Bank of Nebraska have all helped us get this website up. We consider it an objective, independent site to be able to give you information. One thing is clear from today: there is a lot to learn, and there is more to learn as programs open. We do expect to hold additional webinars this year. Look to the website for when. We hope to bring forward those first few states that open ABLE programs on a webinar so that you can ask questions and you can hear directly from those programs about their unique features. We hope to have a future webinar that will feature people who have opened accounts so that you can hear from them, people in different circumstances, parents with young children, working age adults, grandparents, others who have come together to open a ABLE account for someone that they are close to. So thank you today for joining us. This program will be archived on the ablenrc.org website, and please spread the word. This is such an important piece of legislation that was enacted. It took almost 10 years. It offers transformative opportunities. I sometimes call it a down payment on independence and freedom. Changing expectations for people with disabilities, changing expectations for those around a person with a disability to think bigger, broader, and about the quality of life. So thank you for joining us, and we look forward to your using the website and being a part of this conversation nationwide. Have a great afternoon. Take care.